Hello, and welcome to today's webinar, Understanding DC's New Ban on Non-Compete Agreements. I'm Christine Kulamani, staff attorney with the DC Bar Pro Bono Center's nonprofit and small business legal assistance programs. First of all, thank you to my colleague Lauren Paley that has done all of the behind the scenes technical logistical work to make today's webinar possible for us. And of course, a tremendous thank you to our presenter, Scott Burton, Associate Attorney at Hunton Andrew Kurth here in DC. Before we get started, a couple of logistics for today's webinar. For those of you listening live, this webinar will be recorded. To access the recording, please complete the post-webinar survey that you will receive. In addition, you have immediate access to the slides for today's presentation in the GoToWebinar control panel on your screen. This should be under handouts. If you have questions as we go, please send them to us through the questions box in that same GoToWebinar control panel. We'll get to as many relevant questions as we're able to today. With that, after delays and substantial changes, on October 1st, 2020, the District of Columbia's ban on non-compete agreements is going into effect. What the ban is, how it impacts you, are all things that small and large employers are looking to know. While the ban is not universal, it does cover a substantial portion of employees, and the exceptions are relatively narrow. In addition to understanding how existing and future non-compete agreements at your organization may be impacted, keep listening to understand some of the new employee protections and notice requirements that are also covered by the law. And with that, I will turn it over to you, Scott. Thank you.
Thanks so much, Christine, and welcome everyone. I appreciate everyone being here today. Like Christine said, my name is Scott W. Burton, and I'm a Labor and Employment Associate at Hunton Andrew Kurth here in DC. And we've got some very important information to cover on the District of Columbia's ban on non-compete agreements today. And like Christine said, it is very timely as it is going into effect on October 1st. So without any further delay, let's go ahead and get started. So a little bit of background. The DC Ban on Non-Competes Agreement Amendment Act of 2020. That's a mouthful. It goes into effect on October 1st, which is only 4 days from now. A recent amendment to the original law from 2020, DC Bill 24-256, passed in July. It scaled back the requirements of the law, which previously banned nearly all non-compete agreements, to one which permits them under certain circumstances that we'll discuss in this presentation. The prohibitions on non-competes do not apply to existing agreements, which is very important, as long as they are executed before October 1st, 2022. But employers should know that they must still comply with the notice requirements and retaliation provisions that we'll get to later in the presentation, regardless of when the agreement was signed. Now, you might be familiar with similar non-compete agreement bans as other states have them, including Maryland and Virginia. But DC's is by far the most strict so far. It's likely that more states will follow suit in passing non-compete laws or strengthen their current laws. So for purposes of the DC law, what is a non-compete agreement? But before I move on, let's briefly talk about why you as a small business or nonprofit owner might want to enter into a non-compete agreement with employees. The primary purpose of a non-compete agreement is to prevent valuable workers from leaving and taking their skills to a competing firm. As we all know, it can be costly to train employees, and the prospect of training employees for a competitor can give small business owners heartburn. The other primary reason is to protect the business's confidential information and trade secrets. Non-compete agreements often come up in the context of salespersons, for example, who have relationships with clients and customers. Such an agreement can prevent those employees from moving firms and taking their whole book, quote unquote, of business with them. Now, there are disadvantages of non-compete agreements as well. In a tight labor market, high-value candidates may be less inclined to accept a position if they will be subject to a non-compete agreement that could hinder their career flexibility. So the DC law defines a non-compete provision as an agreement or a workplace policy that prohibits an employee from performing work for another for pay or from operating their own business. As one can see from this broad definition, the law covers post-employment restrictions, but also restrictions while the employee is employed. As I've highlighted below, this includes performing work that competes directly with an employer's business. So you can see how this might cause potential problems for business owners. However, there are some important carve-outs for so-called moonlighting, as it's commonly known. I do want to highlight that the workplace policy is part of the non-compete provision ban as well. They are specifically mentioned in there as part of the definition. Now, sometimes folks will download a standard employee template or simply be using an older handbook. So if you're one of those people, and that's all right, just go reread the handbook and make sure that if it contains policies concerning simultaneous employment or non-disclosure provisions, that they comply with the law we're discussing today. Now, this is a bit of a busy slide, but this is the meat of what is permitted by the DC law as amended. So employers may use non-compete agreements or workplace policies during or post-employment to restrict disclosure of an employee's confidential or proprietary information. So that's things like trade secrets, customer lists, client lists, or any other non-public information that the business is seeking to protect. Also pertinent to small businesses is that the restrictions are permitted for the sale of a business to prevent the seller from competing following the sale. That makes sense. You want to get the benefit of the bargain there. And non-compete may also be included in an agreement that provides for long-term incentives. So essentially, employers may still, quote unquote, buy a non-compete when it's tied to bonuses, equity, stock, and other incentive plans that are earned beyond the course of the year, as those provisions are typically included in compensation plans as is. The July Amendment added some additional carve-outs for restrictions during employment. Most notably, those restrictions include instances in which an employer reasonably believes, and we'll get to that active word there, that the employee's acceptance of compensation will result in disclosure of confidential proprietary information or constitute a conflict with the rules governing conflicts of interest in the profession. So note that reasonably believes language means that business cannot institute a non-compete agreement simply because of a hypothetical risk that an employee being paid by another will risk disclosure of confidential information. You have to reasonably believe that acceptance of money will cause that. That will likely be very fact specific, so I won't get into specific hypotheticals there. There are a number of professions with conflict rules, including attorneys, accountants, and architects, for example. And there may be others. Those professions' rules of professional conduct often prohibit the employee from offering their services outside of their employment, so a non-compete would be permitted in that situation. And the last two bullet points there, and I'll leave this slide up since I know it has a lot of text, are very specific. But if you just know that if you operate a college or university and a higher education institution, that a conflict of commitment is defined by the statute as one that would compromise the ability of an employee to perform their duties because it would interfere with their primary duties for the college or university. It's somewhat of a using the word in the definition situation, but if you have a specific hypothetical or situation or are one of those clients, then don't hesitate to reach out to the DC Bar Small Business Clinic.
On that topic, you mentioned professional ethics and some of these licensed professionals, but is it possible that maybe there are other industries where there could be conflict of interest rules or kind of general norms or standards that would apply here and permit a non-compete agreement?
I can certainly think of a situation, where that might occur. I'm not intimately familiar with a specific industry's rules, but I know that there are governing bodies of certain types of industries that might have conflict of interest provisions or rules in them. So that is included. So if there is an industry that has those type of rules, then yes, a non-compete provision or workplace policy would be permitted in that situation.
Fantastic, thank you.
Of course. So next, let's talk about who is covered by this law, because it won't apply to every business and every employee, as we'll see. So only employers who operate in DC are covered. But an important note for employer coverage, the amended definition also includes a person or group of persons acting directly or, keyword, indirectly in the interest of an employer operating in the district in relation to an employee. So what does this mean? It means the definition is likely geared towards, for example, staffing agencies or folks that work in the DC metro area that work on behalf or contract with DC operating businesses. And of course, DC businesses themselves. It's that indirectly language is there to close off the possibility of implementing a non-compete through a third party. Now, the employee coverage is a bit more defined. Employees that spend a majority of their time performing work physically in DC are covered. A majority of an employee's time here means more than 50%. And that second part of the definition expands the scope in the instance in which an employee works in several states, most likely Virginia or Maryland as well, but does not work more than 50% of their time in any of those other states that aren't DC. Also, the definition of employees includes prospective employees who have received an offer of employment and the employer reasonably expects will meet the above definitions. So a business cannot ask an applicant to sign a non-compete before they actually start working in order to get around the law. The takeaway here is that if a company does business in DC and they have a qualifying employee, they may not enter into a non-compete agreement with that employee unless one of the exemptions or exceptions applies, which we're going to cover now. And the exemption section is where the DC City Council listened to small businesses and the feedback and made some changes to the original law. So as you can see, the categories of employees who are not covered by the ban are highly compensated employees, which we'll get into next, partners in a partnership, and casual babysitters. The partners exception is an important one for small businesses and nonprofits who are typically closely held businesses. It's important to have that trust with partners that they won't turn around and compete with the partnership after a sale, merger, or dissolution. So in that instance, a non-compete agreement connected to the sale of a business is permitted. And additionally, it may not be as relevant, but casual babysitters does not include those in a daycare setting, but rather those that perform duties in or around the employer's home. So nannies or caretakers at home, that's where this is covered. This is aimed towards, rather. Finally, it seems that probably as a result of some lobbying here, broadcast employees are covered by the ban at any income level. So broadcast employees include creatives for TV, radio, cable, satellite, or any other entity that provides news, weather, sports, traffic, or entertainment programming. Employers cannot enter into non-competes with these employees. So like I said, let's talk about who are highly compensated employees, because that word is going to be doing a lot of heavy lifting. For most employees, a highly compensated employee means someone who is reasonably expected to earn in a consecutive 12-month period or has earned in the past 12 months $150,000 in compensation. The word compensation is broadly defined. It includes not only salary and hourly wages, but also bonuses, cash incentives, commissions, overtime premiums, vested stock, and a catch-all other payments. The only thing that it specifically does not include is fringe benefits paid in kind or paid in cash equivalent. Since salaries in the district are relatively high for skilled professionals, this will not be as high of a bar to meet for some businesses, considering the definition of compensation, but it's still much higher than other states with similar provisions like Virginia with the $68,000 cutoff and Maryland with a $31,000 cutoff. Those are approximate numbers and that change year to year. For obvious reasons, the threshold for medical specialists is higher at $250,000, and a medical specialist is defined as a physician with a medical license who has completed their residency. And then don't forget that little asterisk there at the bottom. The threshold amounts there at $150,000 and $250,000 will increase with CPI each calendar year if CPI increases. So there's no mechanism for a decrease based on CPI, unfortunately. So it's likely that those numbers will go up in the future and stay at those higher compensation levels. And that actually, I should note, that begins in 2024. So it will not be next year that those change, but more than likely the following year they will go up a bit. They could not, fingers crossed. So the exemptions, these apply to highly compensated employees that we just defined. Again, that's employees making over $150,000 a year or medical professionals making over $250,000 a year. This slide lays out what must be included in the non-compete provision, whether it be an agreement or workplace policy. So the length of the restriction is helpfully spelled out by the law. It's 365 days, 1 year, for everyone except medical specialists, which is 730 days. The timer starts upon separation if it's a post-employment provision. Otherwise, if it's during employment, there's obviously no time limit on it. This is really geared towards post-employment non-compete agreements. The written agreement must also include the functional scope of the restriction. So that's, what services, roles, or competitors an employee is prohibited from being employed in during the length of the contract. This is a common requirement across courts related to the reasonableness of the restriction. So this shouldn't be that new for anyone who has had to, enforce a non-compete agreement. So I'll give an example. A typical non-compete for a salesperson engaged in the sale of educational software, maybe, would state that the employee is prohibited from engaging in the sale of educational software specifically, or from being employed as a salesperson for a company that engages in the sale of educational software. You've got to define the scope, the role that a person is prohibited from accepting, so that an employee who signs the agreement knows what they are prohibited from doing per the agreement.
So Scott, would an example, another one there be, going with this salesperson, not having a non-compete agreement that says, you salesperson at our business cannot go work for an entirely different company doing finance, totally unrelated to sales.
That, in that situation, that's probably unreasonable because it's not in the same, vein as the company that is signing the non-compete agreement. It's not very reasonable that someone would be precluded from working in finance. But I will say that if it is for a direct competitor, then you might have more of a reason to include that, as long as it's related to protecting your business per se. So, like I said, if it's for a direct competitor, you probably have more of a reason to include it in there. But I would just be very careful about defining who those competitors are, instead of saying a blanket, you cannot take a role in finance at any company.
Wonderful, thanks.
Of course. And that's just a very basic hypothetical. There's non-compete agreements can apply in so many different situations, but the salesperson situation is usually a good example. The geographic limitation must also be reasonable. So typically, a geographic limitation is considered in conjunction with the length of the restriction. Of course, that's defined by the statute, so there's no wiggle room there. But for the geographic location, as a general rule of thumb, a restriction to states where the employer actually does business or will in the near future is a good place to start. Just beware of national bans saying you may not work anywhere in the United States, or it likely wouldn't address geographic, but just saying you can't work for any competitor without mentioning geographic location, because that will be seen as a national ban, especially if your business only operates locally for now. So next, we're going to turn to the notice requirements and the prohibitions on retaliation included in the law. These are also very important, so I am prepared to answer any questions, as the retaliation provisions are, as you'll see, they can require some interpretation. So the law requires employers to give employees 14 days to consider a non-compete provision before starting work. Or if the agreement is presented during employment, for existing employees, 14 days before it's required to be signed. When a non-compete provision is proposed to a highly compensated employee, a specific notice paragraph is required, and I'll show that to you on the next slide. It's language that is mandated by the statute. Since the law also applies to employee handbooks and employer policies, there's a notice requirement there too. An employer must provide the written policy containing a non-compete provision within 30 days of acceptance of an employment. That's not the day that the employee begins working, so just be aware of that. The policy must also be provided whenever it changes. So if you plan to include restrictions on moonlighting or conflicts of interest policy in an employee handbook, just make sure that it is distributed to employees after it's updated. And if you already maintain a standalone non-compete policy or have one included in an employee handbook, it should be distributed again before the end of October 2022, because the law does say that it has to be distributed within 30 days of October 1st of the effective date of the law. So that's a sneaky one, but make sure that if there's already a policy that on conflicts of interest or moonlighting, that you're resending out that handbook again by the end of October. And now it's really just a good time to update employment policies or DC specific addendums to comply with the new law. Just make sure that employees that fall under the definition that we covered earlier are given proper notice of the policy. And here's that notice paragraph that is required by law to be included when a non-compete provision is proposed. It essentially discloses to employees that they can only be asked to sign a non-compete in certain situations and directs them to the Department of Employment Services for more information. Obviously, the only change is to input your company name there, or nonprofit name, and name of employer there in the middle. I'll leave it up for a minute so everyone can read it. But in practice, you should just have a copy of this notice language on hand to include in an email when sending a proposed non-compete agreement, or just as a disclaimer in a workplace policy. Okay. So these anti-retaliation provisions might seem broad, and they are, but there's some important qualifications in the language that employers should know. So retaliation is only prohibited for covered employees' refusal to enter into a non-compete agreement if the agreement is prohibited by law. There's a lot of qualifiers there. So if an employee is not a covered employee, for example, a highly compensated employee, then an employer may take an adverse action for their refusal to sign or agree to a non-compete, or for failing to comply with it.
So Scott, just to clarify that, to make sure that everybody is on the same page. An employee that is highly compensated, that is asked to sign a non-compete agreement and refuses to do so, can have adverse action like firing taken against them.
That's right. It can be a condition of employment for a highly compensated employee.
Great. Just wanted to make sure that everybody hears and understands that.
Of course. No, thanks for jumping in with that. So additionally, the ask in that second bullet point there, the asking, informing, or complaining prohibition, again, only applies to covered employees, or actually in this instance, highly compensated employees that reasonably believe that the non-compete or workplace policy doesn't comply with the law. So this isn't a ban on general griping about having to sign a non-compete agreement. The complaints or questions about the agreement must be regarding the legality of the employment agreement or policy. It must be reasonable that the employee believes that it is not legal, not just, you know, an employee saying, I think this is against the law, you know, that we have to do this because this law came down. No, it has to be, you know, specifically, I think this is illegal because, you know, the law says this. That prohibition, again, like I said, applies to both covered and highly compensated employees. An employee may not be retaliated against for requesting information about the non-compete ban, or, as it states in that last bullet point, asking for a copy of their non-compete agreement or what's contained in it. So obviously the easiest way to avoid this prohibition is to just be upfront with employees, give them a copy of proposed non-compete agreements within the notice period and workplace policies in that notice period as well. And just making sure that you're not shutting down employees that are asking real important questions about the non-compete ban or what's contained in the employer's non-compete policy, rather than just the general griping. You know, as long as it's not being disruptive to employment, you know, there's probably some leeway there. And adverse actions are defined by law, and it includes warnings, a reduction in hours, suspension, or termination, or the threat of any of those. I will note that that definition is not as broad as the meaning of adverse action under anti-discrimination statutes like Title VII. So it's a bit narrower what is defined as adverse action. You know, it's not necessarily taking away work or giving worse assignments like it might be in other instances. And let's talk about penalties. The amounts laid out in the penalty section that you see here, you know, may seem small, but there are several ways they can add up very quickly. As you can see, an employer that violates the statute is liable in monetary penalties not only to the city, but to the individual employee too. So each violation ranges from $350 to $1,000 in penalties to the city. That's what goes to DC, and $500 to $1,000 in relief to the employee. And it's $1,500 or more to each employee if the employer attempts to enforce an illegal non-compete provision. And that last bullet point, there's some more aggressive penalties for repeat offenders, essentially. For example, subsequent attempts to enforce an unlawful agreement or policy doubles the fine to $3,000 to each affected employee. Violations of the anti-retaliation provisions are subject to fines of between $1,000 and $2,500 for the first time, and $3,000 for subsequent violations. Again, that's for each employee retaliated against. Another kind of under the radar fine that can add up quickly is a violation of those notice provisions. It's $250 per employee affected. So if an employer fails to provide a copy of the workplace policy that implicates this law by the end of October 2022, and there are a number of employees that are covered, then that's $250 a pop. So make sure that you're reviewing policies and agreements and sending them out within those time periods, 14 days for an agreement and within 30 days for new employees for the workplace policies. The law also provides a private right of action by employees to sue for the violation of the law. They can file an administrative complaint with the Department of Employee Services or an action in court. And as you can see, an employee may also recover fees and costs from that civil action. So that's all to say that the law does have real teeth, by all indications, it will be enforced stringently. The Department of Employee Services has not issued guidance on enforcement yet, but it's important that businesses review their non-compete agreements now and their workplace policies in preparation for that October 1 effective deadline. That's coming up very soon. And that is the end of my presentation here. So if anyone has any questions, feel free to drop them in the chat and I will answer them as best that I can.
Thank you, Scott, so much. So we do have a couple questions that have already come in. And folks, if you have more, as Scott mentioned, send them while we get through these. So you had mentioned, the DC law very carefully defines a non-compete agreement. And it also includes, workplace policies and employee handbooks. But what's the difference between a non-compete agreement as defined in the law and a non-solicitation agreement?
So, of course, that's a good question. A non-compete agreement, essentially prohibits an employee from going and working for someone else for pay. And that could be during employment or post-employment, and it could be a competitor, it could be not. A non-solicitation agreement essentially says that an employee cannot, I'm thinking how to describe this accurately here, cannot solicit business on their own that would compete with the company. So they're pretty similar, but it really applies more to someone who is working on their own or owns their own business, or soliciting customers that are clients that are clients of the business for their own purposes, essentially.
Some way that I've heard non-solicitation described is, thinking about kind of like poaching clients from the former employer or poaching coworkers.
That's right. That's right. It can include coworkers too, and thanks for bringing that up, Christine. So, for example, if an employee has their own side business that may or may not compete with the employer, of course, those policies, they're usually policies and handbooks. That employee cannot say, "Hey, you coworker, I know you do a great job. Why don't you come work for me instead?" Those are usually prohibited by non-solicitation policies as well.
Great. Okay, can we go back, almost to the beginning and really just revisit who covered employees are under this to make sure that everybody is clear who employees that are covered by DC's non-compete ban are. While we're there, maybe talk a little bit about whether or not this ban would apply to properly classified, let's assume, consultants or independent contractors.
Okay, so I'll start with the coverage question. All employees are covered except for highly compensated employees, partners in a partnership, and casual babysitters. So the starting point in any analysis is to assume that the employee is covered. Then one would go down to the exceptions or the exemptions there and see who is exempted. Of course, highly compensated employees are those that make $150,000 a year or more, some medical specialists who make more than that, partners in a partnership. I will also say that the law does permit in the definition of covered, well, it's not in the definition of covered employee, it's in the definition of what is a non-compete agreement. It does permit those types of policies that are otherwise lawful for non-disclosure of confidential information. So I don't want to lose sight of that important carve out there, that policies that an employer institutes that might kind of look like non-compete agreements, but they're really about protecting confidential information. Those are actually not included in the definition of a non-compete provision. So regardless of whether an employee is covered or not, those are permitted. And then I believe the second question, I want to make sure that I answered the last one. Christine, is that sufficient?
Yeah, no, I think that is perfect.
Okay, then independent contractors, I expect some guidance on this to come from the department, but right now I would assume that independent contractors, well, if you have an independent contractor and you're looking to sign a non-compete agreement with them, that starts to look more like an employee. So they're not specifically included in this law, but I would just caution anyone that signs a non-compete agreement with an independent contractor that it might mess with, or cause them to lose that independent contractor status, because one of the definitions, or part of the definition of an independent contractor, is that they're free to offer their services to any number of employees, or employers rather.
Great. Okay, let's see. Is there any exemption in the law for small employers? For example, a small home-based business that maybe only has 1 or 2 employees?
Unfortunately, there is not. It applies to any business with 1 or more employees, essentially. So everyone is covered here, no matter the size. Sorry, I wish I had a better answer, but no, it does cover everyone. It is highly broad law.
And coming back to this really important for lots of small businesses, partners in partnership exemption. Can you explain, just in a couple sentences, how that could apply and create a valid non-compete agreement for, for example, a 2-person owned business?
Yes, of course. So essentially, if you're going into a partnership with someone, you want to make sure that they're not also creating another partnership that might compete with you. So in that instance, those partners, just the partners, are exempted from coverage. So essentially that means that the partners can agree either in their partnership agreement or in a separate agreement between themselves that they will not compete with the business. It should be tied to the business, of course, not that they will not compete with each other, even though partners do make up the business in this situation. The law also specifically addresses a situation where the partners sell the business. So perhaps one partner is selling to the other. And in that instance, of course, there will no longer be a partnership, but the selling partner can still be prohibited from competing with the business once it's been sold, for obvious reasons.
Okay, fantastic. A little, post-COVID world potential question or hiccup that we may not have an answer to yet, but I want to put it out there. Sure. If there were employees that prior to the pandemic worked physically within DC, would clearly be covered by the non-compete ban, but are currently working remotely indefinitely in some other jurisdiction, and there aren't specific plans for when they'll come back to working in person in DC, should the employer treat them as if they're covered by the ban, or is it safe to say until they're back in DC, don't worry, or worry about the ban for wherever they are working?
Well, I think so that goes to the definition of who an employee is. It sounds like the business would be operating in DC, but the employee might not be covered in that situation since they don't spend time physically in DC. Again, like you mentioned, we might have to rely on hopefully forthcoming guidance from the department on that, because remote work is always a concern. I'm sure it's been brought up before, so I imagine it would be addressed in some guidance. But it doesn't sound to me like in that instance that the employee would fit the definition under the law, because they don't spend more than 50% of their time physically in DC.
Fantastic. Okay. And so just to be clear, if a business is DC based, but has employees that work in another jurisdiction, those employees would not be covered by DC's non-compete ban. However, they might be covered by a non-compete ban where they're working, depending on that state's laws. Is that correct?
That's correct. That's a good summary of it.
Okay, fantastic. I'm going to give just another minute or so for any additional questions that may come in. But I have gone through all of the ones we've received so far.
Okay. Well, great. Yeah, I'm happy to hang out a bit longer for any other burning questions that folks might think of.
Okay, I don't think, no more are coming in right now. So, I want to thank you again, Scott, for taking the time today to walk us through, this piece of legislation that is right around the corner for employers. And, okay, one question as I'm doing that. When does the enforcement of the law begin, right? The rules, the actual law starts October 1st. Can DC start enforcing the law on October 1st?
That's my understanding based on the language, the text of the law. It says it's going to be enforced by the department, and there's no indication that they will not begin enforcing it on the date that it becomes effective.
Okay, great.
And I will say one thing. Of course, enforcement might take many forms, but I expect that enforcement largely to stem from specific employee complaints about non-competes that they are being asked to sign.
Yeah, that makes sense. And, as a reminder to employers that are listening, there are provisions and parts about this that you might not have to worry about enforcement quite yet. So, for example, giving notice of existing policies that are covered by the law, you have 30 days to do that. And so you're not going to get in trouble potentially, in theory, on October 1st, because you have 30 days to do it.
Right.
So keep that in mind, right? The law goes into effect, but not everything has the same timeline.
That's a good point, Christine.
And as a reminder, Scott mentioned this, if you as an employer have questions right now about if a policy or part of your handbook is covered by the law, or you're getting ready to hire a new employee or raise somebody's pay and are considering adding a non-compete agreement for them and want to talk through it with an attorney, you can come to the DC Bar Pro Bono Center and you can speak one-on-one with a volunteer attorney at our Small Business Brief Advice Legal Clinic. You can sign up for that, view all of our upcoming events and our resource library, including a webinar of a recording of this webinar and past webinars at our website, lawhelp.org/DC/NPSB. And that's lawhelp.org/DC/NPSB. So please, if as you're going through this, processing the information, you have questions, go to that website, view our resources on everything, but also you can sign up to speak one-on-one with an attorney there. So for our listeners, if you are joining us live, in a minute, you will get a pop-up to complete a participant survey. So please share your thoughts on the webinar there and any topics that you have an interest in future webinars on. And before we wrap up, once again, thank you to Scott and the team at Hunton Andrew Kurth for this presentation today and helping our small local employers prepare for this big change in the DC law.
It's been my pleasure, and I hope it was helpful to everyone.
Fantastic. Thank you, Scott. I hope you have a good afternoon, and I hope that all of our listeners do as well.
Agreed. Have a good one.